Hello again, everyone, and welcome to Quigley on Divorce, a behind-the-scenes look. I'm your host, James Quigley. I am honored to have with me today a special guest, not only a guest, but one of the main partners on my team, Joe Napoli. Joe, welcome.
Good to be here. It's been a while since I've been invited, so it's very much a pleasure, so I appreciate it, boss.
So, as I mentioned, Joe's one of the partners on my team, and just kind of before we get into our topic today, which is going to be parenting time and or restrictions on parenting time, very topical, very important, just kind of to remind you about who we are, what we are, and how we approach things. So within Beermann, we all have teams. We work together. Sometimes we work on other people's teams in cases that warrant it, but the team approach is really what we bring to every case, and it allows different levels of experience. It allows delegation of work at different hourly rates to try to keep costs a little more manageable. The divorce can be very expensive, but it also allows us to be more efficient and more available to our clients. And so Joe started many, many moons ago as a law clerk and then an associate attorney. He's now an income partner in the firm. He is on the trajectory to soon running this place. So we're really happy to have Joe. He's a hard worker. He's an excellent lawyer. Like me, Joe's bent is probably a little more towards the litigation side. We try cases. We go to court. We fight for our clients. We will do mediations. But I think some of what we'll focus on today is going to be more on the things that happen with respect to parenting times when we get into court. So with that as a kickoff, Joe, you'd agree with me that when clients have, hey, and this is early in the new year, so they've said, new year, I've got to move forward. We're going to, part ways. A divorce has started. What is one of the real early on or primary focuses of what we look for at the start of a divorce?
Well, I think in the initial consultation, what we try to do is identify what the goals are of the client. And so today's topic is parenting time. So what we want to do is talk to the client about what their expectation is at the end of the case in terms of parenting time. And once we identify that, we try to back in as to how we're going to accomplish that. So we learn things like work schedules. We learn things like history of caretaking responsibilities. And so we really try to learn the facts and circumstances that would support us accomplishing such a goal.
Yeah, and I think once we have those goals from our clients and we have a little bit of the factual background, our job, and we've talked about this in other podcasts, is we're now developing a strategy. And really issue number one, and again, this is speaking to those of you out there viewing and listening, is those of you with children, is children always have to come first. They are the main priority, and for most of our clients, they are. Money's important, and the division of assets, support, maintenance, all that's important. But the welfare of your children is and should be number one. And so one of the things we look to figure out from day one is what are our clients' expectations with respect to parenting time. And so, Joe, what do we encounter a lot of times when we're dealing with parents and schedules? What are some of the typical things that people look to have in a parenting schedule when they come to us?
Well, outside of the schedule, there's a lot of things that can be addressed with parenting time. You have the regular schedule, then you're going to have holiday schedules, you're going to have summertime schedules. You might have nuances within your family that maybe your family recognizes certain days of the year that other families won't. So those days might mean or have some significance to you or importance to you, so you'll want to carve those out, and those will be topics of discussion. In particular, maybe religious practices, right? So not everybody has the same religious practice. Some families might observe certain ceremonies that others won't. So these are things that you're going to want to share with your lawyer, because otherwise they might not know. So a lot of the information is going to come from you. So you, as the client, are going to be a big advocate, to your case. And how you do that is you let your lawyer know as much information as to what you think is pertinent, and then your lawyer will help you as to how best relay that to the court or to the other side or in negotiations or mediation.
Yep. And I think before even you get into some of the nuance that Joe's talking about is we always want to understand what's the basic framework, okay? A lot of times we have, and maybe you're in this situation, where you're married, this process has now begun, you're going to get a divorce, but you're living in the same house together. It's uncomfortable. Sometimes it's toxic. Sometimes it's abusive. And one parent to the other says, I got to get out of here. And so it's interesting, again, depending on what side of the coin we're representing.
Sure.
We might say to a client, yeah, let your spouse move out. Great. They're not going to take the kids, afford parenting time, but let's keep it limited because that sort of creates a precedent. But if we have a parent who says, you know what, I want to have a 50-50 schedule, we're oftentimes going to say, look, you can't move out. You've got to, because you don't want to create a new precedent where you're only seeing the children on a limited basis. We want to get to a schedule first and then move out. So, Joe, when you have parents, start of a process, getting divorced, one parent comes to us and says, hey, this is the schedule I'd like. How do we move that issue forward early on in a case?
Well, you've got to practice what you preach. So if someone's coming to you saying, or if you want 50-50 parenting time, you have to put your money where your mouth is. So you have to avail yourself to have that amount of time. So, for instance, in this hypothetical, let's say a parent wants 50-50 and they work 70, 80 hours a week. Logistically, that might be tough to put in reality as to practice a 50-50 schedule if you don't have that many hours available to you during the week. So if you want something, let's say 50-50 parenting time and equal schedule, we have to work backward from there, right, accomplishing our goals, and think, what facts are on our side to support that? What time is on our side to support that? What history and practices of child taking responsibilities have we done or undertaken to support that?
And those are good, again, really important things as the litigant is, as Joe's talking about, make sure you're walking the walk. One of the things that we look to do is try to figure out as quickly as we can is if there's a proposed schedule, if our client would like a 50-50. What we try to do is let's interject that into the conversation with the other spouse's attorney as quickly as possible. Sometimes we'll go straight to drafting what's called an allocation judgment, and that's, in the old days, we call them parenting agreements or even joint parenting agreements. And within that allocation judgment, there is a schedule. Children are with dad Monday and Tuesday, with mom Wednesday and Thursday, and then they alternate weekends. That's a typical kind of 50-50 schedule. So getting out a position early on is very, very important, because let's say we do that, Joe, and the other side says, no, we want a schedule where, say, for example, mom will have the children 9 overnights every 2 weeks, and they're proposing dad have 5 overnights every 2 weeks instead of 7 and 7. All right, we don't have an agreement. Well, if we flush that out early on, and we've got a client we're saying, don't move out yet, we want to get a schedule in place, we've proposed a schedule to them, the other side says, no, we don't agree. What's available then as a next step?
Well, I want to talk about, because you raised a really good point about flushing it out. Mm-hmm. So let me go to the converse quickly to that. Let's say there is an agreement.
Yep.
Right? So we flush it out. We have a 50-50 schedule, assuming that's what the parties want, or that's what this particular client wants in that case. Now it's flushed out, and we see that we don't even need to posture in a litigation form because we have what we want. And I think if you have that, you got to strike and get it done. Okay. And I think that's important, that when clients are represented by counsel, if there is a deal, because in this business, things can change very, very quickly, right? It's high emotion. It can be high conflict. How you feel today may not how you feel tomorrow. And so if you want 50-50 parenting time and the other side agrees to that, lock it in now and get it done and take it off the table, because chances are you may not have to deal with that issue, certainly the rest of this case, but maybe in the future.
Yeah.
And now that's not used in other areas, to posture in other areas, whether it's financial or wherever else.
Yeah. So
if going to the question now, if we're at an impasse, there's a variety of things that can be done. There are certain avenues of trying to reach a compromise or a middle ground, right? There's a mediation aspect. That mediation can be attorney assisted, where the lawyer goes with you to help you negotiate on your behalf. It can even be done without lawyers present. And different from financial, when most, I would say in my experience, most always the lawyer's there.
For financial mediation.
For financial mediation, because the client doesn't know the nuances of the law legally, but certainly parents know their children, and they know what's best for their kids. So sometimes the client will go there with the other party or with their spouse or soon-to-be ex-partner and see if a middle ground can be reached. So mediation is certainly a topic, but it is important to flesh out what actually you're fighting for, right? Because you may find out months down the road, oh my gosh, we were fighting for no reason.
Yeah. Well, and I think part of that comes from your interaction with your lawyers and having a realistic conversation. Client comes in and says, I want 50-50, I want 50-50, and like you said, it's that parent who's working 70, 80 hours a week. Historically, that parent hasn't really been a 50-50 parent even within the marriage. And so, to me, I think when you talk about mediation, I agree with you, number one, mediation can be done with two parents. You don't always need the lawyers in that process with you because you know what's best for your family. But if you're going to go into mediation, you have to have a strategy even for mediation. You have to understand your strengths, your weaknesses of your position. You have to go into it with a strategy of what you're willing to maybe compromise on and what you're not. And so whether you do that with a lawyer or just with the other spouse, mediators can help you get to that point of yes, but you got to have a plan. You don't just show up and say, let's just talk about it. You have to have a strategy. What are you willing to compromise on? But really what we're trying to accomplish is, A, making sure you understand what's realistic and we're managing your expectations long term, but also giving every parent the opportunity to avoid what likely will come next if you don't come to an agreement, which is litigation. So we'll talk about some of the things that we do as litigators, as trial lawyers, as it relates to parenting schedules. But our real message is any person coming into a divorce with children, you've got to try to find a way outside of litigation to work out a schedule that's not only best for you two as parents, but more importantly, what's in the best interest of the children. And that kind of goes to what Joe was saying earlier about historically, I have a case right now where historically, mom would take the children to school every day and she got to work early. Dad would get out of work early and would pick them up from school every day. Well, if that's a schedule that's working, why disrupt that just because you want a 50-50 schedule? And sometimes, Joe, we see the motive in this current climate of the law since probably 2016. There's an incentive for both parents to have at least 50% of the time because the child support formulas have a mechanism within the formula that diminishes the amount of child support a payor would have to pay based upon the number of overnights he or she has. So that becomes sometimes something we have to flush out as lawyers too, is do they really have a good argument to have a 50-50 schedule, or is it really just, hey, I want this because I want to pay less child support?
And flushing that out and learning the other side's motive can help you negotiate. Because maybe if there's a financial interest, maybe there's some give on other areas where if you're after a dominant portion of the parenting schedule, you can get that and also appease maybe an indirect want of the other party at the same time. So you definitely need to flush that out. In terms of supporting your position, and what we talked about before we jumped on, it talks about when we were going through objectives and goals, is you have to know what you want, and more importantly, why. Why do you want that? Because you're going to be asked that a lot. In mediation, the mediator is going to ask you, why is that best for your child or children? The judge is going to ask you, why is that best? And if you go to litigation, your lawyer is going to ask you on the stand, which you would hopefully be prepared for to answer, is why is that going to be best for your children? How are they going to be most resourceful and independent and succeed and happy under the terms that you are proposing? So you have to know what you want, but also why do you want that, and have to explain that to whether it's your lawyer, the mediator, a guardian, which we'll get into, a guardian ad litem or child rep, and ultimately, if it gets that far, the court.
Yeah, and I think that kind of segues then into sort of what we deal with quite a bit, which is we have a client hire us, we flush out what their goals are, what they believe is in the best interest of their children. We set forth that position to try to get that off the table. Other side says, nope, this is what they want. We're at an impasse. We go to mediation or some sort of alternative dispute process. Let the parents try to work it out with someone helping them, give and take. That doesn't work. You've got people entrenched in their respective positions. So now we're going to court. Well, what does that mean? Well, I would say most cases where you as a litigant through your lawyer present to the court that there's a dispute over children in the parenting time, and we've tried these opportunities out of court to settle, one of the first things the court's likely going to do is appoint what was called a guardian ad litem, GAL, or a child's rep. And it's usually a lawyer whose charge is to protect and advocate for the best interests of the children. Now, once that person's involved, your children are involved. That's the main point. We're trying to avoid your children being part of your divorce, because it's bad enough that if two parents are actually respectful of one another and get a divorce quietly out of court, that's still going to have an impact on children. We see this all of the time. And so if you now have this battle between mom and dad, and we're now involving the children to where they're being interviewed by guardian ad litems or child representatives, or God forbid we get into these evaluations where there's a psychologist or a psychiatrist, children are being probed, they're being asked questions. They are now the subject of and in the middle of their parents' fight. And so when that happens, not only, as I mentioned, is the court going to put people in place, it's costing you more money, by the way, and it's adding lots of time to your case, because that takes a long time for these investigations go. But we, in conjunction with that, oftentimes really encourage our parents to say, hey, if your child does not have a counselor, a therapist, a school social worker, somebody that they can have a safe space, that they can share the emotions and their fears and their insecurities, all of which they're experiencing, to some professional that can help them through this, they're really going to struggle. And you don't want to wait to say, boy, I wish that would have happened. We've seen children with drug addictions become an issue, school problems where all of a sudden grades are plummeting, criminal behavior all of a sudden by children, God forbid suicide. These things can happen to your children, so do not be naive to that. Take precautions early on, and that's in addition to your own therapist. So those are sort of side comments, the issue of therapy and counseling, but it's a tough process. So let's say we're getting into the situation now where we've got a GAL. They're going to do an investigation. Hopefully we've got some sort of professional help for the child or children. Hopefully mom, dad, or mom and mom, dad and dad have their own personal therapist that they can work through this. But now sort of the floodgates are open.
The floodgates are open. I want to underscore something you said. With the appointment of a guardian ad litem or child rep, and then what you referenced was maybe an expert or professional, right, to do a deeper dive, that's going to cost real money.
Real money.
So you've got one lawyer for you. There's a lawyer on the other side for your spouse or partner. And now you have this independent, neutral third party, and maybe a couple, right? You could have a child rep and then also an expert come in and do a deeper dive analysis. So now you potentially could have 4, if not more, professional fees being charged to the estate or to you or to your pocket. So it's real money. Number 2.
Hang on. When you say real money, just for example, if again, a child's rep or a guardian ad litem is going to get an hourly rate, just like the lawyers,
yep.
right?
Yep.
some of the evaluations, what have you seen in terms of a cost? And I'm not even talking about an evaluator later testifying at trial for which they get paid, but just to conduct this type of evaluation that could be easily 6 months in the making.
Yeah.
What do you see as far as cost on that kind of thing?
We're talking tens and tens and tens of thousands of dollars. And then here's another fee. Yeah. They might, depending on the course and the length of litigation, might have to update it. Yeah. Might have to get a new one because that one got stale and new happenings have happened. So depending on...
Or how about this one? What if the court-appointed evaluator comes down against our client and we don't like it? What are we going to do?
So then you have a reference to a statute, 60410C, which is when the aggrieved party, if you will, or disappointed party can hire their own expert to maybe contradict, maybe not, the expert that already has opined that was against you. That's another fee. And then we're talking about another update. So it's real money if parents don't agree to the schedule. Number two, and this is maybe equally scary, if not more, now someone else is going to make a decision, not you.
For your kids.
For your children. Someone else is going to decide how much time you're going to spend with the child that you were with, right since they were born, you raised it, everything. Someone else is going to come in and say, this is what is going to happen. And here's the thing, that's going to be followed.
Yeah.
You're
judge's order.
That's a judge's order. That's what you're going to live with. That's what your children are going to live with until they're 18 years old-ish. So it's a big expense. It can have real significant ramifications.
Yeah. And I think there's so much to unpack in this, and we've got somewhat of a limited time for each episode, but I want to kind of shift gears a little bit too. So now we're in the mode of, we've already gotten past, parents can't work it out, mediator couldn't help, we're in litigation. What do you do in the situations where it's not, the focus of the litigation isn't, hey, I want a 50-50 versus an 8-6 or a 9-5 in terms of overnights. It's, I don't want the other parent to have parenting time because the other parent is abusive, maybe has addiction problems. When I say abusive, too, it's not always physical abuse, mental abuse, emotional abuse, physical abuse. We deal a lot with narcissism, and people think, well, narcissism can be a form of abuse. The mental manipulation, control, alienation of children through that, it has lasting and negative impact on people who have been abused in that type of a situation for a long time. So let's say, for example, a parent has been abused physically by the other parent, and you say, well, what does that have to do with the kids? Can that result in a restriction on one parent's parenting time?
So absolutely it can. It depends on the facts and circumstances. So abuse, certainly physical, is the easiest types. James talked about different types of abuse. Some you can see, right? There's a bruise. I see it there. There's a photo. There's a video. Pretty easy to identify. Others, there's not. Verbal abuse. He said, she said. He said, he said, she said, she said.
They said.
They said. So there's different types of abuse. Some are easier to prove than others. So when someone has been physically abused, I think one of the first questions we ask is, were the children present? Right? That's a significant factor. Because if the children were present, then we ask, well, if they were present, we're assuming, did they see it?
Or hear it.
Or hear it. How old are they?
Yeah.
Right? Were they in the infancy of their years, 1, 2?
Yeah.
Are they a little bit 7, 8? Are they older? And
was it one time? Is this the 10th time?
Right. And did they see things escalating? So there's a lot of things involved, and abuse unto you by your partner can influence their parenting time with the child because of the significance of that abuse which they cause unto you. Yeah. So a lot of times, and there's rules in this when determining decision-making, which we're not necessarily getting to today, but parenting time is kind of what's the causal connection of the abuse, of the behavior of the parent, and how it impacts the child. Yep. Because if it negatively impacts the child, then it can have severe consequences on the parenting schedule. You talked about a restriction, right? So certain things can happen where all of a sudden there can be a strict restriction on that parent's parenting time where they have maybe someone supervise their parenting time. A third party there just literally watching them to make sure nothing is said or done to that child. And that could last for a significant period of time. If you are a parent that thinks that the other should be restricted, it's important really to advise in the moment, assuming something impromptu doesn't happen. So for instance, if you've been in litigation for 8 months, 12 months, and nothing significant really happens, a new issue, but now all of a sudden it's getting time for trial, and you're going, yeah, I think the other parent should have restricted time. That's what I want the trial position to be.
Yeah.
That's going to be a tough look, because having a restriction is a serious consequence. That means there's some form of serious endangerment unto your child from the other parent. And generally, if something's serious, you let them know in the moment.
Yeah.
So it's important when if you have to go the route of litigation, and if you find out, as James said, flush it out in the beginning to see what in the world we're fighting over. But if there is going to be some conflict ensuing, it's important to advise your lawyer in the moment, as opposed to, well, 6 months ago, he did this or she did this, and that's why I want a restricted parenting time. Because you may have to let those, being the guardian ad litem or the expert, know in the moment, because it captures your sincerity. Because if you don't let them know in the moment, others who are receiving information might not think you are sincere in your concern.
Yeah, and I think one of the things Joe touched on is this concept of serious endangerment. And this is something we deal with quite a bit with our clients who are in these really tough situations, because you could imagine, and I'll just use by way of illustration, if a woman comes to you and she's been physically abused by her husband, very traumatic. It's not just something you say, oh, okay, it happened, right? It stays with them. They're fearful. They're traumatized by that. Sometimes you have these almost PTSD type symptoms that go with that. And so they say, he shouldn't see the children. And it's very difficult sometimes for us to manage the expectation of parents that are in these abusive situations or where there's addiction problems, because you start from the premise that parents of children have a legal right to parenting time with their children. And it takes a showing with evidence that there is some serious endangerment to the physical, mental, emotional well-being of the child to restrict the parenting time. And here's what happens, people, and this is a very hard conversation with clients to understand. It doesn't go on in perpetuity. If your client comes to you or comes to us and says, I don't want my spouse to ever see these kids again, he's so bad, she's so bad, they're so bad, no parenting time. We have to have the conversation that that's not realistic. The other parent's rights are not going to be terminated. The probability of that happening is infinitesimal, right? Now, you can go to the lawyer next door, or the one over there, or the one upstairs, and they'll take your money. Sure, we'll fight that, and you'll spend tens of thousands, hundreds of thousands of dollars fighting to terminate the other parent's parental rights, and it's not going to happen. So you have to be realistic. There are things we can do for you to protect your children in the short term, to make sure that the other spouse, for example, if they're abusive, the court can order them to have some sort of anger management counseling or have ongoing therapy. If they're in addiction, they can have testing to make sure that they're not abusing drugs or alcohol before parenting time. But if a parent who has been guilty of being abusive, neglectful, alienating, addictions, these kinds of things, walks the walk through the process of the litigation, goes through the hoops and hurdles set up by the guardian ad litem, by the court as part of a court order, they will eventually be afforded parenting time, even overnight parenting time. Now, they may have put themselves in a position where a court's going to restrict the amount of time and maybe say, you're not a candidate for a 50-50 schedule because of behavioral issues or this and that. We don't want to put the children at risk. But that's something that is hard to hear from parents who are in situations where the other parent really exhibits this bad behavior towards the other parent and oftentimes towards the children.
There's two sides to it. The offending parent, they're going to get, in my experience, second opportunities, third opportunities, fourth opportunities. Yeah. You and I spoke before jumping on this podcast where maybe you have an absent parent, hasn't seen a child in years, and all of a sudden they wake up one day and say, today is the day I'm going to be involved, and I'm going to petition the court for parenting time. And the parent who has been taking care of this child for years without interruption, without influence of the other parent, without a phone call on a birthday or a holiday, is now saying, how is this possible?
Yeah.
And to what James alluded to is, it's very rare circumstances where someone's rights are going to be terminated. And if they're not terminated, you're going to have second bites, third bites, fourth bites at the apple with respect to parenting time. Now, on the flip side, what happens if you are doing everything perfect and the other parent keeps stumbling, okay, whether it's restrictions or relapses or what have you?
Mm-hmm.
What you hope in a perfect world and what you argue and what generally happens is the window of opportunity gets more narrow for the other parent. So when you come in, there's going to be a presumption that, the parents are fit. But once you start having things and circumstances that limit your opportunity, whether it's a relapse or, drugs or alcohol or whatever it is, your window of opportunity is going to become more narrow. So if you were that parent that came in at 50-50, and now all of a sudden you have an overdose, God forbid, or a relapse or what have you, the judge is going to really be pulling back possibly and saying, 50-50, I don't know, we're going to restrain that a little bit. And then it happens again, right? You stumble again. Now we're going to restrain it even more.
Yeah.
I mean, in a perfect world, that sometimes happens. And when we have these second bites, third bites at the apple, going back to the party who offended the order, they're going to get chances, but it's going to be most likely in a transition phase. It's not going to be reestablished all at once overnight. And I think a good comfort level for parents is, let's see how it goes for a period of whatever, weeks, months, 6 months, whatever it is. Let's see if this parent can handle this type of responsibility. And then we'll build from there, assuming that you're comfortable with it. Because what you don't want to do is overextend, right? And then you have a real issue, the child is involved, and now you got to pull back.
Right. And I think when we talk about these very real issues that we end up litigating, and we're on both sides, if one spouse comes to us and they're the ones, as Joe said, has fallen down, whether it's been through some addiction or they've been inappropriate in their behavior, the message to them is clear. You have to walk the walk. And there's going to a lot of times clients come to us, this isn't fair, and I shouldn't have to do this. Well, if you don't, then you're not going to get yourself back to those rights. When we do these podcast episodes, what I'm going to try to do moving throughout the year is leave you with some tips, right? It's, you hear this stuff, and these are, you hear our anecdotal experiences and the issues we deal with, but really, what's your takeaway from this? Okay, there's a couple, and we started this by saying, number one, work this out yourself. Do not put yourself in a position or your children in a position where they're part of your divorce, or that you are in a position where a judge is going to tell you what your time is with your children. So number one, try everything you can to work this out with the other parent through mediation, through negotiations with your lawyer. Don't go to court. Don't put this in someone else's hands. That's number one. I think the other tip that I would leave you with is, if you're in a situation where we were just talking about, it's not that, hey, you're a good dad, you're a good mom, you're a good mom, dad. We really have someone who has a problem, whether it's abusive behavior, whether it's some sort of addiction problem, whatever the issue is, it's not as simple as saying, let's do a 50-50 or an 8-6, okay? Well, what do you do in that situation, okay? And Joe touched on this, because if you are seeking to restrict the other parent's time, it is your burden legally to have evidence to convince the court that there should be a restriction. And if you can't prove that with evidence, you're not going to be able to get those restrictions. So how do you do that? And that's the tip I'm getting to. You have to document things real time. And Joe talked about this. If we're 8 months into litigation and all of a sudden you say, oh, he or she drinks too much. Why is it an issue now, right? When things happen, even if you're in a marriage now or you're in a relationship and abuse occurs, you've got to document that. What's the appropriate way to document abuse? Call the police. Fill out a report. If it's physical, if you've been physically assaulted or intimidated or assaulted verbally, threatened, I'm going to kill you, I'm going to do this, you call the police and you document that. If it's more sinister, if it's the narcissism, it's the manipulation, it's the control, you have to document that stuff. And again, it sounds weird. People keep journals. It's almost like keeping a journal. You have to document this real time. Why? Because if you go back historically and look, and you say, these are my recitations of what happened, and I'm not saying, oh, she's a bad person or he's a bad person. I'm saying this is what happened. Date, time, right? Facts. What are the facts? This happened this day. This happened this day. I've got a real-time chronology of this cumulative abuse. That can be used. You can look back historically. So you've got to get documentation. If you are harmed physically, you take pictures. If you've got bruises, cuts, a doctor's report. You have to be honest with your physician when you go in and tell what happened. So my tip is, number one, best you can try to work it out parent to parent. Number two, if it's a situation where it's not that easy, there's a reason the other parent shouldn't have parenting time or should have restrictions or shouldn't have a 50-50. Document those things. Joe, any other thoughts before we close it out on the issue of parenting time?
I think just know your why. I think it's important as a final takeaway, know your why and be able to explain why you want what you want and why that's going to be best for your child.
Yeah, and that's good advice. And understand, we, here at Beermann, we've been in business for 65 years, and it's because we try to do things the right way. And the right way, from our perspective, is always, as best we can, let's try to protect children. We don't represent the child in a divorce, but we take on that responsibility through our client in trying to make sure that they're protected. So if you find yourself in a situation where you're going into a divorce and you've got issues with respect to your kids, what's the schedule going to be? We haven't been able to work it out. We don't have my lawyer doesn't have a strategy. I don't have a lawyer yet. How do we approach this? How do we follow your tips to make sure we protect our children as best we can? Those are the times that I suggest you reach out to us. Contact us. Our website is www.beermannlaw.com. 2 E's and 2 N's in Beermann. And again, within the website, we have our profiles. You can reach out to Joe. You can reach out to myself. Again, my email address is jmquigley@beermannlaw.com. And Joe?
jnapoli@beermannlaw.com.
Great. And 312-621-9700 is our office line. Joe Napoli, James Quigley. Really hope that this was helpful for you. Again, even if you have questions, feel free to contact us anytime. If you want to get on social media, I'm at Quigley on Divorce. You can direct message me with any questions or even other topics you'd like us to share, or any specific questions you might have from this episode. But again, children first. We wish you well, and we're here if you need our help. Thanks for joining. See you next time.